Good afternoon, everyone. Welcome to the Assembly Committee on Commerce and Labor. Mr. Secretary, please call the roll.
Assemblywoman Carlton.
Here.
Assemblywoman Considine.
Here.
Assemblywoman Dickman.
Here.
Assemblywoman Duran.
Here.
Assemblyman Flores.
Present.
Assemblyman Frierson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Martinez.
Present.
Assemblywoman Marzola.
Here.
Assemblyman O'Neill.
Here.
Assemblywoman Tolles.
Here.
Chair Howdigi.
Here. Mr. Secretary, please indicate that all committee members are present. Welcome to our audience tuning in over the internet. Before we start, I would like to make some housekeeping announcements. Please remember all exhibits, written testimony, and amendments must be submitted by noon on the business day prior to the committee meeting. Persons who wish to provide testimony or attend the meeting virtually must pre-register online. The public is strongly encouraged to submit written testimony in advance of the meeting by emailing asmcl@asm.state.nv.us. Zoom chat is reserved for committee business only. Members, please remember to keep your camera on at all times. This will help us ensure we have a quorum, unless you are stepping away from your computer for non-committee related business. Members and presenters, please remember to be muted at all times. Unmute yourself to speak and then promptly mute yourself when you are done. Thank you to everyone. Let's begin with our first agenda item. Our first agenda item for today is going to be a presentation from the Nevada State Contractors Board. And I believe we have the Executive Officer, Margie Grain, here to present.
Good afternoon, Chair Howdigi and members of the committee. My name is Margie Green, and I've had the pleasure of serving as the board's executive officer for the past 23 years of my 35-year career with the board. On behalf of the board, I would like to express my appreciation for the opportunity to provide you with an overview of our board. Our mission is to promote public confidence and trust in the competence and integrity of our licensees while protecting the health, safety, and welfare of the public. My presentation today will walk you through the operations of the board. Let me share my screen here, sorry. Okay. My presentation will walk you through the operation of the board and some of our most recent accomplishment and activities. Hopefully you all have a copy of the handouts I provided to the committee. These provide you with an overview of our legislative package, our constituent services, and our operational highlights for fiscal year 2019-20, which I will make reference to in my presentation. If there are no initial questions, I'll go ahead and get started.
Okay, Ms. Green, if you would begin, thank you.
Thank you. The Nevada State Contractors Board was established in 1941 by the Nevada Legislature and is comprised of 7 members, including 6 licensed contractors and 1 representative of the public. Each member is appointed by the governor for a 3-year term. Our board meets monthly to provide staff direction on policy and governance matters, in addition to developing an annual strategic plan that outlines goals and objectives to be achieved each fiscal year. We have a number of subcommittees that meet as needed, with the exception of the Residential Recovery Fund, which meets every other month and is comprised of 3 board members. The Contractors Board is self-funded by the revenue received from licensing fees. We are not part of the general fund budget, although we do remain under the executive branch of government. Our board has maintained an operating reserve policy since 1948 which has been modified over the years based on our auditor's recommendation to comply with the most current financial statement reporting requirements. Our current operating reserve policy was revised and approved by the board most recently on October 12, 2010, following audit recommendations received by the board CPA firm, which is to maintain a one-year operating reserve. The board employs personnel between our two offices in northern and southern Nevada and maintains our own benefit and retirement packages. The Contractors Board has never been a part of PERS. However, we have been an active participant in Social Security and offer both a 401A employer-funded retirement plan as well as a 457B employee-funded retirement plan. We currently license 17,717 construction businesses in the state of Nevada, which include both residential and commercial contractors. Licensees consist of corporations, LLCs, partnerships, and sole proprietors. Of the current licensees, 16,687 are in active status, while 1,030 are in inactive status. 265 licensees hold veteran or military status. Of the licensees, approximately 33%, or 5,802, are from out of state, with 5,347 of those in active status and 455 in inactive status. Comparatively, 11,915, or 67%, are based in Nevada, with 11,340 active licenses and 575 inactive licenses. Each of these licensed entities are directly responsible for the hiring and employment of the estimated 95,000 workers in Nevada's construction industry. Our licensing process includes, among other requirements, a review of the applicant's experience, financial wherewithal, and character. Applicants are required to take and pass the business and law exam, which tests the applicant's understanding of applicable state laws and knowledge of operating a business, as well as required trade examinations. Nevada's license classifications range from specialty licenses, such as plumbers or electricians, to general contractors. Projects can range from small home repairs to large-scale projects such as the Allegiant Stadium. The board currently has license by endorsement opportunities with 12 states, including Alabama, Arizona, California, Connecticut, Florida, Hawaii, Louisiana, New Mexico, North Carolina, South Carolina, Tennessee, and West Virginia. This program allows for the endorsement of trade exam and/or trade experience requirements when applicants meet the requirements. Making licensure more accessible for those who have an interest in starting a construction business in Nevada is something the board remains committed to. To give you an idea of the work performed by our licensing department during the past fiscal year, 4,627 new license and license change applications were received, and 7,482 license renewals were processed. Our licensing data often correlates with the economic conditions of the state, and surprisingly enough, during this past year, we noticed the slightest decrease, less than 1%, in the number of new license applications over the 2018-19 fiscal year period, even as the construction industry weathered the COVID-19 pandemic. In fiscal year 2019-20, we received 1,991 new license applications compared to 2020 in fiscal year 2018-19. Since 2017, our board has been engaged in Nevada's team participating in the National Occupational Licensing Consortium, which aims to identify potential barriers to licensure and labor market entry, while also seeking opportunities to expand license portability and endorsement programs. From this engagement, we were able to implement several strategic initiatives to address these concerns, including implementing regulations related to licensure by endorsement that allowed the board to recognize licensure and exam from other states in consideration of the Nevada application, researching the various trade examinations and experience requirements of each state to identify those that are most in line with Nevada. With this information, we were able to produce a state equivalency chart, which applicants can use to determine whether or not they could apply for a waiver of our trade exam or experience requirements. We've worked with our exam provider to allow applicants to take Nevada-based exams in any of their approved facilities across the nation. And lastly, we've been making efforts to raise awareness of our small business assistance and veteran assistance programs. These programs provide for individualized assistance to veteran and veteran spouse applicants and offer monthly seminars to business applicants that provide information concerning application requirements and other helpful tips. In addition to our licensing efforts, our board maintains the responsibility to ensure those we license comply with the statutory and regulatory provisions under NRS and NAC Chapter 624. Our enforcement division includes 3 departments. The compliance department investigates all complaints received by the board related to licensed contractors, which typically fall into one of 3 categories. Workmanship complaints coming from property owners, which may include but not limited to abandonment of a project, failure to correct, or failure to complete contractual obligations. The second is money owing complaints involving contractors and subcontractors, suppliers, or vendors. And the third category is violation of industry regulations. These offenses normally concern violations of law, such as failure to obtain a building permit, hiring or doing business with an unlicensed contractor, or failure to maintain industrial insurance. Our criminal department investigates all unlicensed contractor complaints and may forward validated cases to the local district attorney's office for criminal prosecution or take administrative action. In addition to investigating complaints, our criminal investigators coordinate unlicensed contractor sting operations, proactively monitor a variety of electronic means where construction-related services are being advertised, such as Craigslist, Facebook, and other online bulletins. The board's fraud unit is charged with taking on significantly complex cases of contractors who prey upon unsuspecting homeowners, often senior citizens, by committing felony crimes, including obtaining money under false pretenses, diversion of funds, and property theft, amongst other things. The fraud unit also assists licensed contractors who have been victimized by embezzlement through criminal activity, such as theft, diversion of funds, forgery, and misrepresentation. Because many of these cases are often rejected by the courts as civil matters, the ability for the Contractors Board to investigate the allegations and prepare criminal charges with enhanced penalties for crimes against seniors has been successful when presenting the case to the district attorney or attorney general for prosecution. The efforts of our fraud unit have resulted in the prosecution of and conviction on multiple criminal fraud cases, which have resulted in both restitution to the victims and prison time for the offenders. During fiscal year 2019-20, our enforcement division received 2,630 complaints, processed nearly 3,400 fingerprint cards, and performed 179 background investigations. A total of 406 administrative citations were issued. We filed 104 criminal cases with the district attorney's offices, issued 372 cease and desist orders to persons operating without a license, and investigated 19 cases alleging fraudulent activity. Additionally, the board held 154 disciplinary hearings, which resulted in the revocation of 54 contractor licenses and fines assessed of more than $410,000. The money received from fines is deposited into the Construction Education Fund and is distributed by the Commission on Construction Education in the form of grants to community, educational, and industry-affiliated organizations wanting to implement and promote construction education and workforce developments in the state of Nevada. The commission is comprised of a total of 7 members, 1 member who's a member of the board, and 6 members appointed by the governor as follows: 4 members who are representatives of the construction industry, and 2 members who have knowledge of construction education programs. In fiscal year 2019-20, the Commission on Construction Education awarded nearly $298,000 in grants to 11 programs. The Commission has awarded just over a total of $3.9 million since inception in 2001. Additionally, the Residential Recovery Fund Subcommittee considered 107 claims and awarded nearly $1,050,000 to harmed homeowners, many of who were senior citizens that had been taken advantage of, or homeowners who their projects were abandoned. The Recovery Fund is an important protection we offer owners of single-family residents who hire licensed contractors because it allows them to receive financial recourse up to $40,000 without having to go through civil litigation. Since the first claim was paid in 2001, the Recovery Fund has awarded over $13 million to harmed homeowners across our state. And I can tell you firsthand, there is no greater feeling than helping a homeowner who has been harmed by an unscrupulous contractor. While much of our work centers around the accountability of our licensees and regulating their ability to follow the laws of the state, our greater purpose and outcome is measured by the people that we protect each and every day. We have developed a number of programs that include a senior citizen awareness program that addresses construction-related scams and highlights the resources available by the board, a home improvement forum that brings industry professionals and the Contractors Board together to highlight the importance of hiring licensed contractors for homeowners of all ages looking to engage in home repair or remodel projects, and an informational program that has been provided to community managers, realtors, and governmental agencies responsible for hiring contractors. The board facilitates construction career panels to educate and inform at-risk populations, students, and others about employment in the construction industry and how this is a viable career option. Also, we hold virtual and in-person when we can legislative town hall events to raise awareness of the board's resources and related public safety initiatives and programs. Topics included in these forums include the value of hiring a licensed contractor, home repair scams and how to identify them, and a joint task force that we are on with the Labor Commissioner. We make an effort to meet with the various industry associations to share the objectives and activities of the board, seek their input, and proactively address their concerns. We partner with governmental agencies to promote collaborative initiatives such as fraud protection, and we've developed a series of material and informational videos which we make available to the public on our website and social media platforms. As noted earlier, it is the Contractors Board vision to be a model regulatory agency, which is why we engage in our strategic planning session discussions to reflect on environmental changes and recent experiences in order to continue advancing the services of the board. We're proud of the efforts we make to protect the public and promote the integrity of the construction industry. I'd like to thank you again for allowing me to be here today, and I'm more than happy to answer any questions you may have.
Thank you so much, Ms. Green. I am going to turn it over to the committee members first. Committee members, do you have any questions?
Madam Chair, I do.
Vice Chair Carlton, please.
Thank you, Madam Chair. So, Ms. Green, nice to see you. It's been a while. You're one of the few people that's been doing this just a little bit longer than me. So nice to see you're hanging in there. So I want to talk about the recovery fund, and because I think there's a lot of folks don't realize it's out there. And I'm trying to remember when we actually set that up. And I've had some folks ask me questions about how they can access it and who can access it. So could you expand upon the recovery fund a little bit more, please?
Certainly. The Recovery Fund was formed in 1999 by Assembly Bill 636, sponsored by Speaker Buckley at the time. And we've modified that over the years, but it applies to owners of single-family residents who contract with a licensed contractor who have been damaged by failure of that contractor to perform adequate services. It does not apply to renters. It does not apply to property owners. It's only the owner of a single family residence. Now this year, and you will see, we have brought forward one bill today, which we'll be getting at later, that modifies that a little bit. But we try to make that process as easy as possible. Most of the time, the contractor involved has either gone out of business or abandoned the project or left the state. And so this is a resource for the homeowners to be able to apply to the fund and submit their claim, and we pay up to $40,000 or $750,000 aggregate for one contractor. Say, for instance, the solar contractor a few years ago who had close to $2 million in claims, and at the time the limit was $400,000. So those owners only got a prorated share of the fund. So now at the last session, we increased that to $750,000 or 20% of the fund, whichever is less. We provide information on our website to homeowners that they can download the forms. They can file those electronically. By statute, we have to act on those claims within 6 months from the date a completed claim is received. For the most part, most of the homeowners, sometimes we have a couple of claims where they may have current litigation going on at the same time. They'll ask to continue that, so that will stay that or told that statute of limitations.
Thank you, Madam Chair. Just a couple brief follow-ups. So how much is in the fund currently?
Currently, we have $5.8 million.
Okay. All righty. I guess one of the concerns that I have is that if you're a homeowner, but it's a second home that you're working on and you hire a contractor for, that if something would happen to that home, you're not allowed to access the recovery fund, but you're just as damaged because you are the homeowner, but it's not your, I guess, what would be considered primary residence. So I guess I'm just a little confused why we would penalize someone who had already been harmed by a contractor by not allowing them to get compensation back from the fund.
And I believe those discussions occurred initially when the bill was enacted in 1999. And it was just the decision of the legislature along with the board. We weren't certain if the fund would be healthy enough to provide, it was all new to us. And I couldn't really, I do have our legal counsel on, but it's just the definition of a single family homeowner or owner who resides in the residence. We are making a couple of changes to the bill this session or that we're proposing today, but it's just always applied to the owner of a single family residence who resides in the home. I'm sorry,
Okay.
I can't be a little bit more specific on that.
No, and that's fine. And I remember the original conversations because we didn't know how much money was going to be in the fund. How much do they contribute to the fund? How is it assessed?
The licensed contractors pay into that, and I just have my handy little book here. So it's according to their license limit. So if they have up to $1 million, that fee is $200 per biennium. If they have a limit of $1 million, but it's limited, that's $500 per biennium, and unlimited is $1,000 per biennium. So it's a graduated scale on the amount they pay.
Okay, thank you very much, Ms. Green, for the information. I think it's worth having the conversation. Harm is harm, whether it's the primary residence or not. You were just as harmed by a contractor, and that contractor has paid into that fund. So I think anyone who's been put in this position should at least have some avenue to address what's happened. So I'll let that one go for now, and we'll have further conversations with it in the future. Thank you very much, Madam Chair.
Thank you.
Thank you, Vice Chair. Those were great questions, some of which I had myself. Is there any members with other questions? Okay, Assemblywoman Duran?
Thank you, Madam Chair. My question is, do you have to have a contract with that, or could it be verbally? We recover the funds.
Thank you. We prefer a written contract. It makes it much easier, but then as you know, a contract can be verbal. If the owner can show proof that they paid money for some work in return, we can establish that. But we try to encourage everyone to get written contracts, but I can tell you that is not going to prohibit us from investigating that case and trying to make that determination.
Thank you.
Thank you.
I'm going to jump in as well, just because I did have a question on the recovery fund as well. Now, you said it has to be a licensed contractor. So somebody who hired a contractor thinking they were a licensed contractor, turns out maybe they were an unlicensed contractor, wouldn't have access to the recovery fund?
That's correct. The fund is paid for by licensed contractors and that's why we try to promote the hiring a licensed contractor on every corner, because it does not apply if they hire an unlicensed contractor.
Okay, thank you, Ms. Green. And then members, any other questions? Okay, then I do have a couple. I know you mentioned that your board members were appointed to 3-year terms. Can they rerun or be appointed again for a second term?
Yes, they can, Chair Howdigi. I believe last session there was a change in, I want to say it's 232A, but I'm not sure that's the statute, where a member cannot serve more than 12 years. It was either last session or the session before, but they can reapply. And that statute went into effect for terms from that point forward, so it was not retroactive.
And then I just have one last question for you, Ms. Green. I know you mentioned that you guys employ Nevadans throughout the state in the north and the south. How many employees do you have? And then is everything paid for through the fees that you collect, even their salaries?
That's correct. We currently have 46 employees. I had furloughed some of the positions when COVID started a year ago. We, of course, are hoping that some of those positions will be brought back. And you're correct. We are our personnel structure. We are not employed through the state of Nevada. Through our payroll is separate. Our benefit packages are separate. It has been like that since 1941. And I believe we are one of maybe 2 boards that has that operation.
Thank you. Members, any last questions? Okay. Oh, I did have one last question, Ms. Green. I know you had mentioned, it's going back to the recovery fund, that we actually changed the structure of the recovery fund to do $750,000 or 20%, whichever is less when it's a group, like a class. But didn't we also increase it per homeowner, the award amount as well?
Yes, it went from 35,000, Madam Chair Hudigi, to 40,000.
Okay, perfect. And that was it. Okay. Thank you, Ms. Green.
Thank you.
It looks like we are all caught up with questions. So thank you so much for your presentation. And I think you're going to be joining us for our next agenda item as well. Okay, members, that concludes our presentation from the Nevada State Contractors Board. Next up on the agenda, we do have 3 bill hearings that we will be hearing today from the State Contractors Board. We're going to take them in order, and we're going to begin with Assembly Bill 49. Ms. Green, I believe you will be presenting Assembly Bill 49, or do you have someone with you to present?
Thank you, Chair Hudigi and members of the committee. I do have someone with me today. It's our board's counsel, Tim Guesswine. If we could get him on, and I will turn it over to him to give you the overview on our 3 bills, which we have amendments for all 3 as well. Mr. Guesswine, are you there?
Yes, ma'am.
Okay.
Good afternoon, Chair Hudigi and members of the committee. My name is Tim Guesswine. I'm the General Counsel for the Nevada State Contractors Board. The first statute that we have proposed, AB 49, and I'll share my screen in case you haven't seen the proposed changes. AB 49 proposes some revisions to the NSCB's disciplinary statutes. So after meeting with the stakeholders and internal review, the board is now asking that the original changes expressed in the statute of sections 1 and section 2 be omitted from the bill. Those statutes would remain then in the statutory scheme unchanged by AB 49. So with that edit, section 3 in the original draft would now become section 1. Section 1 proposes a revision to NRS 6243016 sub 2. This statute imposes discipline upon contractors for committing certain crimes, including crimes of moral turpitude. Because the term crimes of moral turpitude is vague, the board proposes to use instead the crimes listed in an existing licensing statute, NRS 624266. The licensing statute, 624266, requires applicants for a license to disclose certain crimes. So with this revision, the disciplinary statute will mirror the application statute and will make it clear that crimes against a child, sexual offenses, murder, voluntary manslaughter, and any other felony or crime of moral turpitude will now be a cause for contractor discipline. This more comprehensive list will protect the public and remove ambiguity about the causes of discipline for committing certain crimes. The final portion of this statute simply now as the renumbered section 4 becomes section 2, so the act is effective upon passage. Are there any questions about the board's AB 49 for the executive officer or for me?
Madam Chair, you're on mute.
Thank you, Vice Chair. Okay. Members, do you have any questions? Unless Ms. Green, do you have any comments that you would like to add?
No, I think Mr. Guesswine covered it for us, but I'm happy to answer questions if you have any.
Okay, thank you. Members, questions? It looks.
Yes, I do have.
Madam Chair, just Oh, I'm going to start with the Vice Chair, Vice Chair Carlton, and then it looks like I have Mr. O'Neill and then Ms. Tolles. Vice Chair, we'll start with you.
And I believe Ms. Considine had a question also. But,
okay.
Just to help you manage all the different screens. So my
Thank you.
Mr. Guesswine is, when I looked at the reference to 62.266, is the term moral turpitude still in that citation?
So responding to the member through the chair, yes, the NRS 624266 does still include the term crimes of moral turpitude.
Okay, so what are we fixing if it's still there? I thought the whole idea was to get rid of moral turpitude.
Well, and we can remove that. There's been some discussion about it. We do believe that 266, that existing statute, the application statute, does clarify what would be a cause for discipline. But in the term crimes of moral turpitude is vague. However, there are times that we know, or some crimes that one could easily say is a crime of moral turpitude. This is really an issue that we can fully flesh out and we can strike in its entirety if that's everyone's desire.
I just wanted to make sure that we were all on the same page. You're eliminating it from one section and citing a section that it still exists in. So it seems to be a bit of a round robin. So I just wanted to make sure that was on the record, Madam Chair. Thank you very much.
Thank you, Vice Chair Carlton. Okay, next it looks like Assembly Member O'Neill had a question.
Thank you, Madam Chair. Hopefully this can be a quick answer. Can you explain to me why we're dropping all of sections 1 and 2?
responding to the member through the chair, after,
Mr. Guest, you can go directly to the member. Thank you.
thank you. After we had exceptional and lengthy discussions with members of our community, our stakeholders, contractors, organized labor, other interested parties, and many people believe that those changes were unnecessary and could create two problems. The first problem, unintended consequences to local building codes, and secondly, remove defenses for contractors subject to discipline.
I like it, quick and easy. Thank you.
Assemblymember Tolles?
Thank you, Madam Chair. Can you hear me all right? Great, thank you. And yep, most of my questions have been addressed through the amendment because I too had some concerns there. And also thank you to Vice Chair Carlton in regards to Section 3, also noticing that moral turpitude is in that NRS statute. But I do appreciate that it does add value to have some clarity over what specific types of crimes may be subject to discipline. So I don't know if it's a question more than a comment, because I think the last two speakers addressed my questions.
Thank you, Assemblymember. And then we have Assemblymember Considine.
Thank you, Madam Chair. And I think this is along the same lines. I just want to clarify it for myself. The changes that you've made in the amendment, you are simply taking those sections out of the bill, not out of the NRS, correct?
That is correct. Those statutes will remain unchanged in the existing statutory scheme.
Thank you.
Okay, members, any further questions? Okay, seeing none, thank you so much for your presentation. I am going to move this bill hearing over to the testimony part of the bill hearing. We're going to start with people who are here in support of Assembly Bill 49. I believe we have Mr. Richard Daly.
Thank you, Madam Chair, and I'll be quick. Skip Daly for the record, representing Labor's Union Local 169. And I was reached out to by Margie Green, Director of the Contractors Board, regarding all three of these bills today. And just wanted to lend our support after discussion. I think the change is reasonable, and yes, the two provisions will remain in the bill that are being struck in the amendment. But after the discussions, we were comfortable with the change, and we believe it makes sense to move forward. And Ms. Green asked me if I would lend my support after our discussions, and I agreed that I would, so here I am. Just wanted to add our support to that. Thank you.
Thank you, Mr. Daly. Next, we have Mr. Chauncey Chowdong. Is he with us? Okay, we can move to, we have Mr. Jim Hoffman.
Good afternoon, Chair. Jim Hoffman, representing Nevada Attorneys for Criminal Justice. We support this because we know that in empirical terms, one of the best ways to prevent people from committing crimes is for them to have actual legal jobs. And the current language on moral turpitude is really vague and ambiguous. So it doesn't do a good job of screening out the people who are actually dangerous versus the people who are just trying to get back on their feet. So we support this bill. We support the amendment. We would certainly support what Vice Chair Carlton was saying about taking it out of the other section as well. Thank you.
Thank you. Next, we have Ms. Kendra Bertsky. With the Washoe County Public Defender's Office. Oh, here we go. Okay. I believe you're on mute. No, Ms. Bertsky, we still can't hear you. Okay, I am going to move on to another testifier in support, and we will come back to you. Okay, next, it looks like I have Tori Kalinski.
Yes, thank you, Madam Chair. My name is Tori Kalinski with the Southern Nevada Chapter National Electrical Contractors Association, and we just want to lend our support for Margie Green and her efforts. And this bill, we want to give our Contractors Association all the tools that they need to do the great job that they do.
Thank you. And next, we have Alexis Motorex with the Nevada AGC. Is there anyone here from the Nevada AGC? Okay, we also have Mr. John Hero with the Clark County Public Defender's Office.
Good afternoon, Madam Chair and members of the committee. We are also in support, but we do recognize the problem that Vice Chair Carlton had brought up, and perhaps that statutory language could be cleaned up, because it is important to provide access for people trying to get a second chance in their lives to become a contractor and move on in that direction, which is a well-paying job. So we definitely support the intent of the Contractors Board in moving this bill forward. And perhaps if we could clean up the language, as Vice Chair Carlton said, this would be an even better bill, but nevertheless, we would still be in support.
Thank you, Mr. Pirro. Mr. William Stanley with the Southern Nevada Building Trades. Okay, is there anyone here with the Southern Nevada Building Trades? Okay, let's go back to Ms. Kendra Bertsky with the Washoe County Public Defender's Office.
Good afternoon. Can you hear me this time?
Yes, we can. Thank you.
Perfect. Thank you so much, Chair Howdy. I appreciate it. And thank you to the committee. The Washoe County Public Defender's Office is in support of this bill as it's amended. We did have concerns regarding the initial section 1 and 2 and appreciate the sponsor removing that language from the bill. We do believe that this will reduce the barriers for licensure that will allow more of our citizens to become part of this great profession. So we appreciate this. Thank you.
Thank you for your testimony. Broadcasting, do we have anyone on the telephone line wishing to give testimony in support of Assembly Bill 49?
Yes, Chair, we currently have 4 callers on the line.
Okay, let's begin with the first caller. First caller, if you would please state your name and spell it and identify the organization that you're with, and you may begin.
To testify in support of Bill AB 49, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 116, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Thank you, Madam Chairwoman. My name is Alexis Motorex, ALEXIS Motarex, representing the Nevada Chapter AGC. I apologize for technical difficulties earlier. AGC is in support of AB 49 as presented with the amendment. We would like to thank the Contractors Board for meeting with us and addressing our concerns with the original bill and appreciate the clarification of what constitutes moral turpitude as this bill defines it and removes some ambiguity. Thank you.
Chair, there are no more callers in support at this time.
Okay, thank you. It doesn't look like we have anybody signed in on video for opposition of Assembly Bill 49. Broadcasting, do we have anyone on the telephone line that's in opposition of Assembly Bill 49?
To testify in opposition of AB 49, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Okay, thank you. It doesn't look like we have anyone signed in for video conferencing in the neutral position for Assembly Bill 49. Broadcasting, do we have anyone on the telephone line?
To testify in neutral for Bill AB 49, please press star 9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Okay, thank you. And I would like to go back to those who are wishing to testify in support. It looks like I was quick and I didn't give Mr. Chauncey Dong the opportunity to actually unmute himself. So I'd like to take one last testimony in support of Assembly Bill 49. I know you were having some technical difficulties, Mr. Chauncey Dong, but are you there?
Yes, do you hear me, Chair?
Yes, we can. Thank you.
I appreciate that, Madam Chair. I'm having some technical difficulties. I can't even turn on my camera, so it's just one of those days. So I appreciate your indulgence. Good afternoon, Madam Chair, members of the committee. Chauncey Chowdong on behalf of the Las Vegas Valley Water District. Just wanted to provide testimony in support of this bill, and to also let you know that we will be working with the Nevada State Contractors Board to possibly include water theft as a cause for disciplinary action. We are seeing numerous instances of water theft throughout the Las Vegas Valley, and certainly understand that it might be difficult for the Contractors Board to utilize and dedicate resources to investigate this issue, but we will certainly work with them to see if we can come to a resolution. Again, thank you for allowing me to comment on this bill and apologize for the technical difficulty.
Oh, there I am. It looks like I was muted. Thank you, Mr. Dong. And we all have technical difficulties during this virtual life that we're currently living in, but thank you for your testimony. With that, we've taken testimony in support, opposition, and neutral. I will close the hearing on Assembly Bill 49. Okay. Ms. Green, I believe I have you back with us to present Assembly Bill 50.
Thank you, Chair Hodegui. And yes, I will be turning this once again over to Mr. Geswine to review the proposed amendment on this bill. Thank you.
Sounds great. We will now open the hearing on Assembly Bill 50. Mr. Geswine, please begin when you're ready.
Thank you very much. Assembly Bill 50, which has also been revised from its earliest publication, proposes revisions to NRS 624212, which was amended in 2019. Now, this statute is the cease and desist statute. This is the order the board can give to an unlicensed person who is acting as a contractor in the state of Nevada. The board enjoyed a lot of success with the changes made in 2019, but through experience, we've realized we inadvertently created some hand ties for the board's ability to select among possible cures for unlicensed contracting. Now remember, unlicensed contracting has been illegal or unlawful in the state of Nevada for at least 50 years, per NRS 624700. So after meeting with stakeholders, the board is proposing some change to AB 50 to clarify the possible ramifications of unlicensed contracting are not mutually exclusive. I'm hoping I'm sharing my screen now. Am I?
Yes, we can see it.
Thank you. So this is the primary change. With this change, after the board confirms the compliance with a cease and desist order to the unlicensed person, the board will act by either issuing an administrative citation as allowed by NRS 624341, or by referring the matter for criminal prosecution as allowed by NRS 624700. No changes are proposed to either of those statutes, 624341, the admin cite statute, or to 624700, the criminal statute. These changes with AB 50 then permissibly allows the board to take two other actions. They may require the applicant to submit a bona fide application for licensure, or may refer the matter to a civil court to seek injunctive relief. These changes to 624-212 clarify the possible consequences of unlicensed contracting and mandate certain actions and cures. That concludes my presentations, but I'm happy to answer any questions, as is the executive officer.
Members, do you have any questions?
Chair, I have a question.
Assemblymember Tolles?
Yes, thank you so much. And forgive me if I'm just need a little bit of clarification as I read through this. So in reading the bill, I see that we're removing under section 1 subsections 3, and then altering subsection 4 and 5. And so could you just walk me through what we're losing, or what we're really taking out by taking out section 3? Because as I read it, it seemed that there was a graduated process of action, starting with issuing, essentially, it's not a warning, but essentially it looked like there was a first offense, there was a written administrative citation, and then second offenses comes with reporting the violation of cease and desist and so forth. So could you just walk me through what substantively that changes by removing section 3?
Thank you. To address the question, by removing this section, we really lose nothing in the sense of what the board may do regarding the unlicensed person who is acting as a contractor. Instead, what we've done is created more flexibility on how to address that particular situation. We maintain all of the same tools we had before, but what we don't have is the exact path to follow, which in some circumstances had led us to conclusions or certain circumstances that we would have preferred a different route. Please recall that most unlicensed contracting occurs at a very small scale. Small homeowners who are taken advantage of by persons who literally knock on their door or advertise on social media. They take their money, they perform no work or exceptionally low quality work. In those circumstances, many times the best mechanism for us to get real help for those persons can be referral for criminal prosecution, so that there's a more clear criminal restitution process, as opposed to the administrative citation process, which is difficult to find restitution for homeowners. We think that these changes open up the menu of options and make unlicensed contracting even less of a problem for Nevada citizens.
I see. So it allows you to skip that administrative step if the violation is severe enough that it's best to go straight to other actions. But you can still use the administrative step if that's more applicable or appropriate for the circumstances.
Yes, you completely understand. That's exactly our hope, that we create a broader approach, not a one-size-fits-all.
Great. Thank you so much. I really appreciate the clarifications.
Vice Chair Carlton?
Thank you, Madam Chair. And I think Assemblywoman Tolles addressed my concern. I think I just want to make sure I can wrap my brain around it. So all the discussions that we had about cease and desist last session, we are not changing any of that. That regime still stands. We're just adding a component to it. Is that correct?
Yes, responding to the question, that is correct. So what we're doing with this change is the cease and desist to the unlicensed person will still be issued. The board will still follow up to make sure that the cease and desist order has been obeyed. What the change does is then give a broader menu of options to the board on how to handle that event of unlicensed contracting. We believe
So they can either, and if I may, so that they can either become licensed because they didn't realize that they should have been licensed, or if they don't want to become licensed and they keep being a bad actor, you can go after them criminally. Is that correct?
Under this iteration of AB 50 I discussed today, either a citation will be issued or criminal prosecution. One of those two things must occur. Then there are other options regarding forcing or encouraging licensure to bring those persons into the tent of contracting.
So I guess my confusion is if you issue a citation, won't that count against them when they come to get licensed?
When the application is considered, of course, the whole facts and circumstances will be investigated. I like to believe that unless many times it's simply persons who failed to understand that what they were doing was contracting. This is the small, landscape jobs who just didn't understand that they had slipped themselves into contracting under 624.
Okay, I guess I just have concerns with the citation, the mandatory citation and no discretion. There typically is some type of just discretion in that. So thank you very much, Madam Chair.
You're welcome, Vice Chair Carlton. But that actually, so currently in the statute, that created a question for me. So currently right now, as the NRS reads, if you issue a cease and desist order, do you automatically issue an administrative fine and citation?
Yes, a citation would automatically be issued under the existing statute.
Okay, and then I just want to go back because I was writing down some notes, and I'm sorry, I just going to take this point of privilege to jump in because I had some questions right in the area that Vice Chair Carlton touched on. But during the presentation, you'd mentioned that in the last year, there was 406 administrative citations issued. Now, do you issue administrative citations for other reasons other than cease and desist?
Yes. A licensed contractor may also be administratively cited, and this is usually for an industrial regulation violation.
Okay. And then the presentation noted that 104 were criminal activity in cases that were referred to the district attorney's office. Of those 104, are those all cease and desist, or are there other types of cases that are referred?
It's my understanding that every one of those would have received a cease and desist if they were under 212. Yes.
So then all of those would have been second offenses, correct? Because currently you can't refer a case for criminal prosecution to the district attorney's office without there being a second offense.
I'm not completely certain. It's my broad understanding that sometimes the citation is not accepted and then it can be sent for criminal prosecution.
So then if you can refer for criminal prosecution currently, does that make this bill necessary? Because that's what you're trying to accomplish with this bill, correct?
Yes, we're certainly trying to clarify the statute so that it's more understandable.
Okay, let's see. I'm going to go back to members. Members, I'm checking chats and I don't see anything, but does anybody have any questions? Okay. Thank you, Mr. Giswain. I am going to go ahead and move this over to testimony in support of Assembly Bill 50. Let me check my sign-in list. And it looks like we do have some people who have signed up to support Assembly Bill 50. We can start with Mr. Skip Daly.
Thank you, Madam Chair. Again, Skip Daly for the record, representing the Labor's Union Local 169. And hopefully I can shed some light on some of the questions and various things that came over. I did spend quite a bit of time talking with Executive Director Green on this issue. As some of you may recall, we did spend a lot of time last session working on this cease and desist. And we did want to remove some of the discretion. When we talked about it last time, primarily we were focused on contractors in commercial work outside their scope, above their license limit. They knew better, or they were just straight unlicensed. And the board issued the cease and desist. They had the 48 hours to tidy up the job, public safety issues, but then they had to stop work. If they didn't stop work, the board had ability to go and do injunctive relief and various things, but a citation was required. Now, the level of the citation depended on some certain factors, which is further down in the bill you have in front of you and in the statute. On if certain factors are met, then they have to get the maximum penalty. In the discussion that we had, in the change that we then made, and it goes back to the recovery fund as well, the contractors board pointed out that when they had this situation where there was a unlicensed contractor on residential construction, a homeowner who was potentially damaged, and the contractor was just flat out not licensed, they couldn't get access to the recovery fund. So they wanted to be able to make it so that instead of only having the administrative penalty route, they wanted to do, if we can't do the administrative penalty, we want to be able to do the criminal prosecution as an either or, but we have to do one or the other. And then that would allow through the criminal prosecution where they prepare the case, they turn it over to the DA, or the court, and they could ask for restitution to those homeowners that don't have access to the recovery fund. That's the way it was explained to me on what the problem was. Now, I was happy to hear that the board did indicate, and they testified here today as well, that what we did last session, to their surprise, worked as planned and actually worked fairly well, with that one exception for those homeowners that hired an unlicensed contractor, didn't have access to the recovery fund. This will correct that, is my understanding, and why we are agreeing to the change. So they changed the may back to shall. You shall give the administrative penalty, or if it makes more sense for those homeowners in that situation, they shall go forward with the criminal complaint and hopefully give opportunity for those homeowners that don't have access to recovery fund to potentially get access through the court or recovery through the courts. That's the reason we're in support. Wanted to hopefully shed some light on some of the questions and things that came forward. All the rest of it doesn't change. We were concerned about that. Like I said, we spent a lot of time, and I know Ms. Green pointed out to me that the three bills they had on the contractors board were introduced very early and heard very early like this, but one of the last ones passed. I told her I'd help her not have that happen again this time. She reached out, and we are in support with the changes that they have, and I hope that clarifies some of the questions that people had. That's the way it was explained to me. That's the way I believe the bill reads, and I think it will solve that unintended consequence from last session. Happy to answer any questions if you had any.
Thank you, Mr. Daly. We appreciate that. I do remember Assembly Bill 27 from last session. Thank you. Next, it looks like we have Ms. Kendra Bertsky with the Washoe County Public Defender's Office.
I'm testifying in opposition to this bill. I'm sorry.
Oh, okay. Thank you. We have you signed in support. Okay. Let's move on. It looks like we have Mr. Jim Hoffman with the Nevada Attorneys for Criminal Justice signed in support.
Yeah, I'm sorry. This was a mistake on my end. We're also in opposition.
Okay. Okay, Mr. Dylan Keith with the Vegas Chamber. Mr. Dylan Keith. Okay, let's go and move forward to Tori Kalinski.
Yes, Madam Chair, I'm wondering, is it possible for me to ask a question of Mr. Guestwine through the chair?
We're just taking testimony in support and opposition.
Okay, then,
Sorry, we're not in opposition.
okay. Okay, the National Electrical Contractors Association is in support of the bill.
Thank you, Ms. Kalinski. We appreciate your testimony. Mr. John Piro with the Clark County Public Defender's Office, we also have you signed in support.
And Madam Chair, John Piro, I apologize. We should be in opposition as well.
Okay, thank you. Mr. William Stanley with the Southern Nevada Building Trades. Mr. Stanley? Okay, broadcasting. That looks like that's everyone that we had signed up who's participating on video conference in support. Can we check the line to see if there's anyone on the telephone line who's signed up to testify in support of Assembly Bill 50, AB 50?
Yes, Chair. To testify in support of Bill AB 50, please press star 9 now to take your place in the queue. Caller with the last 3 digits 081, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Thank you, Madam Chair and members of the committee. This is Dylan Keith, DYLANKEITH, Policy Analyst with the Vegas Chamber. We are in support of AB 50 as we believe it'll increase safety as well as increase parity between those that are licensed as required by state law and those that are operating without a license. We also believe this will provide much needed relief to homeowners and increase integrity of the industry. It is for these reasons that we are urging your support on this measure.
Thank you, Mr. Keith. Broadcasting, do we have anyone else on the line to testify in support of Assembly Bill 50?
Chair, there are no more callers in support at this time.
Okay, we will move into opposition. We can start with Ms. Kendra Bertsky.
Good afternoon again. Kendra Bertsky with the Washoe County Public Defender's Office. Thank you, Chair. We appreciate the ability to testify today. At this point, we are in opposition to AB 50, specifically regarding Section 1, the new subsection B in the amended version of the bill on page 4, which includes the requirement of potential prosecution on all cases. We agree with the intention that we want to support our community to ensure that homeowners are not victimized. We believe that there are several ways that we can protect our community while stopping the bad actors without necessitating the initiation of a costly and potentially lengthy criminal prosecution. Our concern with the bill as written and with the amendment is that the criminal prosecution will become the first option without utilizing the administrative citation potential possibility. We believe that the best remedy to stop this type of action is for the administrative citation, and then to have a graduated sanction prior to initiating criminal prosecution. We are concerned that this will not provide the homeowner with the remedy that they are seeking. Restitution can be provided in other ways, for example, through a civil proceeding. We appreciate the opportunity to speak with a sponsor. We appreciate that they are willing to continue the conversation with us to see if there are other ways that we can support their intentions. Thank you very much.
Thank you for your testimony. I am going to move on to Mr. Jim Hoffman with the Nevada Attorneys for Criminal Justice.
Thank you, Chair. NACJ echoes what Ms. Bertsky said, and that's why we oppose this bill. I would also make the point that there were all those protests against mass incarceration last summer. And I think one thing that showed was that our society, anytime there's any kind of a problem, it gets resolved through the criminal justice system, even when that's maybe not the most appropriate or the most effective way of solving that. And so, we're certainly responsive to what Assemblyman Daly was saying about the problems with people getting restitution. But if you put something through a criminal process, you're not just getting restitution, you're causing like lifelong problems for people in terms of get a conviction on their record that makes it harder for them to do things right and be a legit contractor in the future. So we don't think this is the proper remedy for this problem, and we oppose it. Thank you.
Thank you for your testimony. And it looks like we have Mr. John Pirro with the Clark County Public Defender's Office.
Thank you, Madam Chair and members of the committee. We are also in opposition for the same reasons that our colleagues to the north is. This is basically shifting the cost, removing the administrative process and the due process therein is shifting the cost straight to the criminal justice process. So the system will pay, and what will happen is lawyers from our office will be appointed to represent people in these cases, and we routinely are, and the state is appointed to prosecute these cases. The trials are long, and restitution isn't always given as much as we would like it to be. Sometimes you cannot squeeze water out of a rock already. We believe that perhaps going through the administrative process first, and even maybe providing some avenues for the Contractors Board to seek restitution before moving into the criminal justice arena may be the best way to function here at a start, and then using the criminal justice system as a last resort. We do want to say thank you for the bill sponsors for meeting with us and speaking with us on such a quick notice and turnaround, and we fully expect to keep working with them to hopefully move us out of the opposition in the future.
Thank you, Mr. Pirro. Broadcasting, can we check to see if there is anyone wishing to testify in opposition to Assembly Bill 50 on the telephone line?
To testify in opposition of Assembly Bill 50, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, Broadcasting. And I don't have anyone signed up who was wishing to testify in neutral on this bill on video conferencing. Can we please check the telephone line to see if there was anyone wishing to testify in neutral?
To testify in neutral on Bill AB 50, please press star 9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you. Ms. Green and Mr. Guesswin, would you like to give any final remarks on Assembly Bill 50?
Thank you, Chair Hodegui. I would just like to note that we did receive a call this morning from the Public Defender's Office, and we have set a meeting up with them for tomorrow. So we'll try to address their concerns and see if we can come up with an agreement to go forward.
Thank you, Ms. Green. Okay. I will now close the hearing on Assembly Bill 50. Ms. Green and Mr. Guesswin, I believe I have you with me for our last bill of the meeting, which is Assembly Bill 51. I will now open the hearing on Assembly Bill 51. Ms. Green and Mr. Guesswin, you can start when you're ready.
Thank you. Once again, Chair Hodegui, members of the committee, I'm Margie Green, Executive Officer of the Contractors Board, and I'll be turning this over to Mr. Guesswin to present the last bill on the agenda today.
Good afternoon, Tim Gaswine, General Counsel for the Nevada State Contractors Board. AB 51, which has also been revised from its earliest publication, proposes revisions to the Recovery Fund, a fund of monies assessed from residential contractors to cure harms caused by some contractors to Nevada's homeowners. In 2019, the maximum award in an individual claimant was increased from $35,000 to $40,000. Building on the success, the board recognized that further changes would improve the statutory scheme. I hope I've shared my screen. The primary revision is in Section 1 of AB 51, which defines single-family residence. This definition allows all stakeholders to more accurately know who may be an eligible recovery fund claimant. This would be a new statute, but it matches the current practice of the Recovery Fund Committee when making awards. When considering the statute, the competing interests of the recovery fund's financial stability, the contractor's ability to pay assessments, and the administrative efficiency as the claims are considered were all taken into account. With these changes, it becomes clear who is eligible for recovery fund while maintaining the recovery fund's financial health. Another highlight is in Section 4 of the bill. Here, the proposed amendment changes the recovery fund's subrogation right. Currently, under the existing statute, if an award is made by the recovery fund, the injured person assigns all rights to the recovery fund. With the proposed change, the subrogation right is limited to the amount the recovery fund award, the amount that's actually paid. This will allow a Nevada homeowner who has suffered harms in excess of $40,000, the current award cap, to seek recovery fund awards, and after getting that award, to seek recovery for the excess amounts by other methods. The final substantive change is in Section 5 of the Act. The current statute requires residential contractors to give notice to homeowners regarding their recovery fund rights. Failure to do so can result in an administrative fine that is paid into the recovery fund. Section 5 of AB 51 increases the fine amounts. So, for a first offense, the fine would increase from not more than $100 to not more than $250. And for a second or subsequent offense, from not more than $250 to not more than $500. Keep in mind that all monies collected under this violation, these administrative fines, pay into the recovery fund and help maintain the recovery fund's health. That's my presentation. I'm happy to answer any questions, or I'm sure the executive officer can help as well.
Thank you. I know I have some questions from our members. I'm going to start with Assemblymember Considine.
Thank you, Madam Chair. My question concerns the initial addition of mobile homes or manufactured homes that are converted to real property, and then it being taken out and specifically listed as a term, under does not include specifically any mobile home or manufactured home. Why it wasn't included? Because as housing costs go up, what I'm seeing is that seniors are moving into manufactured homes that are converted to real property, and the overlay on top of that is that seniors are targeted for fraud. So I was just wondering if you can explain to me why they're not included in this recovery fund.
Yes, of course. Answering directly. In 2019, some changes were made to statute that allows Nevada contractors, licensed contractors, to do some work inside a manufactured home. But as we considered this bill change and the definition of single-family residence, we began to recognize the role the Division of Manufactured Housing plays and how that separate entity has its own internal workings. And we also had a concern that this might too quickly open up the eligible persons such that the recovery fund's financial health would be adversely affected. And then because of the interaction between the Division of Manufactured Housing and the Contractors Board, there was some concern about our ability to administrate those matters effectively. And that is why we recommended the change to remove manufactured housing, which has never been eligible for recovery fund awards, into the ineligible category.
Thank you. And Madam Chair, if I may ask a follow-up.
Yes, Ms. Considine, please.
So do you know, I know it's not your area, but do you know if the Division of Manufactured Housing has any type of a recovery fund or something that would help specifically this population if there were contractor fraud?
It's my understanding, and subject to check, that their statutory scheme does not include a recovery fund.
Thank you.
Members, are there any other questions on Assembly Bill 51? Okay, I'm not seeing any hands raised.
Madam Chair, this is Assemblyman Flores. I apologize.
Oh, yes, Mr. Flores, please.
Thank you, Madam Chair. And again, my apologies. I was a little bit late to send you that message. I just wanted to quickly follow up on Assemblywoman Considine's line of questioning. And could you give us any idea how many folk are reaching out right now who are, are stating they have claims and are living in manufactured homes? And, I'm just trying to understand. I think I've heard the phrase 3 times now, the health of the fund, so obviously we're concerned about depleting those funds and making sure that it's there. But I'm trying to understand just how many folk are reaching out. Do we have any type of data from manufactured homes concerned that they were victimized, that, they were taken advantage of? Do you have any type of anecdotal data you could provide?
Yes, answering directly. 2 occasions in the last 2 years. A person who owns a manufactured home has sought recovery from the recovery fund.
Thank you.
Any follow-up, Assemblymember Flores?
No, Madam Chair, thank you.
Okay, I do want to follow up on Assemblymember Flores's question. On that line of question, do we know how many homeowners have sought recovery for a non-owner occupied residence?
I'm sorry, I don't know the data for that. You're referring to a situation in which a person who owns a single family home and rents it and then makes a recovery fund refund request?
Yes, correct.
I don't have that data.
Oh, okay. If it's available, would you mind sending it to the entire committee? I'm just curious to see. I mean, there was only 2 who had requested assistance from the manufactured mobile home area. I'd be curious to see how many requests come in for homeowners who have suffered damage but could not seek recovery because it was either a second home or a non-owner occupied rental property. And I just want to clarify, because I was reading what is excluded from the recovery. So if the property is being rented to a family member, although it's a non-owner occupied residence, it's still a rental property, but it's being rented to a family member, as defined here in the bill, they would be eligible for recovery because they are a member of the owner's family. And I'm sorry, I should let you know what section it is to help you identify. I apologize. I'm looking at section 1, sub 2. Looks like it's B, where it's listing section 1, sub 2, sub 3, where it says the term does not include, and then it says personal property, any mobile or manufactured home, and then item E, it says, any dwelling that's rented, but then it says excludes, not a member of the owner's family. So if I'm reading this correctly, then if they're renting it to a family member, they would be eligible for assistance.
That is correct. And this is the scenario one occasionally sees in extended family living, say an older family member or a person with a disability, or even younger, family members, grandparents and the like. The sort of the casita on the existing real property. There might be some contributions by the family member that lives in the casita to the broader household. That would be a covered, an eligible claimant.
Oh, okay. So it has to be a dwelling on the owner's primary residence, because right now it reads any dwelling or real property improvement which is rented or leased. So it has to be like an accessory dwelling on the primary residence's lot.
Correct. Or even imagine say, the adult child who lives with parents and contributes rent to the household. They may have the understanding may be I'm renting a room for mom and dad. The home would still be eligible for recovery.
And then I'm not sure if you have these stats as well, but can you give us, if you don't have them, if you could just provide them to the committee? I'd like to see on average how many claims are filed a year and how much money is awarded. If you could, maybe if you have that for the last 3 years, just so we can kind of get an idea. Because I mean, the recovery fund, it seems to be in a healthy status. I think I wrote down what I know Assembly Member Carlton asked the question. There's close to $6 million currently in the recovery fund. So if it's not being drawn down at levels where we're going to be concerned for the health of the recovery fund, then I think it would maybe be in the best interest of Nevadans who are hiring licensed contractors to be eligible for this recovery, whether they're in a mobile home, manufactured home, or it's a non-owner occupied residence. I'd like just to see how many actual claims there are coming in and what's being awarded, just to see how fast the recovery fund is actually being drawn down.
Chair Hodegui, I'd be happy to get you that information in the next day or so. And the fund has diminished from last fiscal year by about $500,000. So it has decreased a little bit. We keep a very close watch on that and are mindful with the claims being paid, but happy to get you all the data on the fund. So.
Thank you. And then I just have one last question. Was the discussion ever had, instead of increasing the award amount for an owner-occupied single-family residence, was the conversation ever had, instead of increasing that award amount, to maybe open it up to other recipients?
No, we have not had that discussion.
Okay. Thank you. Okay. I'm going to do one last check to see if members have any questions. Members? Oh, Assembly Member Tolles? And then I have Assembly Member Hardy.
Thank you, Chair. And I apologize, but we went through it so quickly. It was really hard to see on the screen share that first page, section 1. And I was looking on Nellis to see if I could find the amended version. Do we have that? Are we going to get that quickly? Could we flash that back up on the screen again?
Yeah, it should be in Nellis, Assembly Member Tolles. You can't find, I'll check with our committee manager, but that amendment should be there. I'll make sure the committee members have it.
And maybe I missed it. Maybe I was looking in the wrong place. That's certainly possible. Thank you.
Thank you, Madam Chair, for the question. I see, since we're talking about the manufactured homes, I think Mr. Yaswine, I think that's how you say your name, said something about manufactured homes. There's specific contractors that work on manufactured homes. Was that one reason like they're not included in this recovery fund? Did I understand that correctly?
Answering directly, prior to 2019, that legislative session, it was unlawful for a Nevada licensed contractor licensed under NRS 624, Chapter 624, to work on a manufactured home unless that contractor also possessed a license issued by the Manufactured Housing Division. That changed in 2019. In 2019, the Manufactured Housing Division sought a change that a licensed contractor performing some work on a manufactured home would not be automatically unlawfully contracting. That would not automatically take that contractor out of scope. Those changes needed some regulations, and I'm not sure the status of those regulations by manufactured housing, but it did say that work performed on the structural elements or the fuel component systems of a manufactured home were expressly excluded. The Contractors Board does not have the expertise to understand the distinction between a structural component in a manufactured home or the fuel systems of a manufactured home. And that's why we are reluctant to enter into this arena as far as recovery fund award goes.
Okay, thank you for that clarification. I appreciate that.
Assemblymember Tolles, I have confirmation that the amendments are actually on Nellis. You might just want to try refreshing it. I've received confirmation from our policy analyst and our committee manager that they are there and available for committee members.
Wonderful, thank you. I must just need to refresh it because it's still not showing up, but I'll look again. Thank you so much.
You're welcome. Committee members, any other questions?
Yes, Madam Chair. I just need to clarify something. I'm getting a little confused. Thank you.
Yes, Vice Chair Carlton, please.
Thank you. So when we changed it, I believe, was it 17 that we allowed contractors to work on mobile homes, but they had to get approval from the Manufactured Housing Division. Is that what I heard you say?
2019. I believe it was Senate Bill 371.
Oh, 2019. Okay. So the years blend together. Those are the same contractors that are paying into the fund, correctly? If they're working on a mobile home, but they're still paying into the fund.
That is correct.
Okay. But because they're working on a mobile home, that homeowner can't have access to the fund even though the contractor paid into it?
Yes, as this is drafted, that's correct.
Okay, Madam Chair, I think that makes it really clear. If the contractor's paying it, and that was the whole idea behind it, and they happen to work on a mobile home, I believe that mobile homeowner should have some recourse. Now, if they're dealing with strictly manufactured home handyman or someone certified there, and that person is not a licensed contractor that did not pay into the recovery fund, I can see the nexus there. But if a contractor has paid in and that homeowner has been harmed, they should have access. To me, it just fits together. So I should probably in the future have a conversation about that. Thank you very much.
Thank you, Vice Chair Carlton. Okay, thank you so much, members. At this time, we are going to move and we are going to hear testimony in support of Assembly Bill 51. I do have a few video participants signed up to testify in support. We'll start with Mr. Skip Daly with the Laborers Union Local 169.
Thank you again, Madam Chair. Skip Daly for the record with the Laborers Union Local 169. And we're in support of the bill as amended or as proposed, and various things. Also, you did have a good discussion. We have less concerns over the recovery fund and how that operates than we did with the previous two, but we are in support. Of course, if you guys make some changes, I'm sure we'll be okay with those as well. Thank you.
Thank you, Mr. Daly. We also have Mr. Dan Morgan with the Builders Association. Mr. Morgan? Okay, I actually don't see him up on the video screen, so we can move on to Mr. Matthew Walker with the Southern Nevada Home Builders Association. Okay, broadcast, do we have anyone signed up in support of Assembly Bill 51 on the telephone line?
Yes, Chair. To testify in support of Bill AB 51, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 184, please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Again, caller with the last 3 digits, 184. If you could please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Chair Howdy and committee members. I apologize for the technical difficulties. My name is Matt Walker, and I'm pleased to testify in support of Assembly Bill 51 on behalf of the Southern Nevada Home Builders Association. The Recovery Fund has been in existence for 20 years. It's been incredibly successful in quickly making homeowners whole when a contractor has not addressed a problem or completed work. The fund is offered in a consumer-friendly format and does not require legal training or contracting expertise to navigate. In most cases, are resolved very quickly. Ultimately, SNHBA sees the recovery fund as our commitment to homeowners. Assembly Bill 51 will maintain access to the fund for homeowners and increase clarity regarding eligibility. For that reason, we are in full support. I would also like to extend our thanks to the Nevada State Contractors Board. Margie and her team reached out to the building community early and often on all of the bills that you heard today. We certainly value our partnership with the Contractors Board and thank the committee for making time to hear Assembly Bill 49, 50, and 51 today. Thank you.
Thank you, Mr. Walker. Broadcasting, do we have anyone else on the line?
Yes, Chair. Caller with the last 3 digits, 500. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Madam Chairman. For the record, Dan Morgan with the Builders Association of Northern Nevada and the Nevada Home Builders Association. The Builders Association and the Nevada Home Builders Association have taken every opportunity possible to highlight the importance of the Recovery Fund as an effective alternative to litigation. The Recovery Fund provides a tested and efficient remedy for consumers victimized by defective work. Homeowners' claims against the Recovery Fund are adjudicated within 6 months. By contrast, most lawsuits take years to be resolved. We are in support of AB 51 because it ensures the ongoing viability of the Recovery Fund and the protection of homeowners and ensures that contractors are held accountable for substandard work. We would like to thank the Contractors Board for working with the home building industry, not only on AB 51, but also to address builders' concerns on other boards this session. I would like to make one note that we will be looking into the amendments made to AB 51 and will respond appropriately at that time. I would like to thank you for your time this afternoon and thank you all for your service to our great state. Thank you very much.
Caller with the last 3 digits, 282. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Madam Chair, Bill Stanley for the record, representing the Southern Nevada Building Trades Union. I apologize for my technical difficulties here today. We are also testifying in favor of AB 51, and I would like to also at this time support AB 49 and 50 that was brought by the Contractors Board. I apologize for not being on when those were heard, but as amended, we are in support. We would like to thank Margie and the Contractors Board for working with the Southern Nevada Building Trades and coming to an agreement on the bills and how they are brought to you today, for you today, and we are in support. And so thank you very much.
Chair, there are no more callers in support at this time.
Thank you. Next, we will hear testimony in opposition of Assembly Bill 51. I don't see anyone signed in to participate on video. Is there anyone on the telephone line broadcasting?
To testify in opposition of Bill AB 51, please press *9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, broadcasting. Is there anyone wishing to testify who is in neutral on the telephone line?
To testify in neutral for Bill AB 51, please press *9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you. Ms. Green and Mr. Guesswine, would you like to make any final remarks on Assembly Bill 51?
I have none at this time. Chair Huddy.
Thank you. Okay, I will now close the hearing on Assembly Bill 51. Okay, we have one last item on our agenda, and that is public comment. So we will be moving on to public comment. Before we go to this agenda item, since this was our first meeting hearing bills, I just want to remind those present and listening on the internet and calling in for public comment that public comment is an opportunity to discuss general matters that fall within the purview of this committee. The public has already been given time to support or oppose specific legislation. We open and close hearings on bills so that we can establish a record of the public testimony on the bill. Therefore, public comment is not intended to continue a bill hearing. Broadcast, do we have anyone on the line for public comment? I will remind everyone during this time that we take 30 minutes of public comment, and public comment is limited to 2 minutes.
Chair, the public line is open and working, and there are no callers at this time.
Thank you, Broadcast. Let's go ahead and give a minute to those who might be listening over the internet that may wish to call in. Broadcast, has anyone called in to provide public comment?
Chair, the public line is open and working, and there are no callers at this time.
Okay, thank you. Thank you, members of the committee. This will conclude our committee meeting for today. Our next meeting will be on Wednesday at the hour of 1:30. Our meeting is adjourned.